Thanks, everybody. It's a pleasure to be here today, even if it is on some short notice. My name is Derek Hughes. I am an attorney practicing in Orange County, California here. I work at the firm Smith LC. The managing partner's name is Stephen Smith. And up until about 10 a.m. tomorrow, he was supposed to be here to give this presentation. Unfortunately for him and for you, he is currently in day 15 of a 4-day trial. This is a trial regarding a trust. There's approximately $40 to $60 million at stake. And one of the things that you learn about litigation pretty quickly is that it can go in directions that you do not anticipate. So, for the last 4 years, these parties have been in litigation on this issue. They've been trying to get to trial. At the entire time, they've anticipated that this first part of the trial would take 4 days, and they're in day 14. We're going to talk about this a little bit later, but his apologies for not being able to be here. He is an amazing lawyer. When I graduated from law school, I went to Columbia Law School in New York, and when I graduated from law school, all of the guys I graduated with, for the most part, headed off either to work for federal judges or to work at very large firms. The large firms at that time were paying and are still paying insane amounts of money to new lawyers, even though a new lawyer knows absolutely nothing about how to practice law. 3 years of law school does not prepare you to practice law. It prepares you to take the bar exam, and that's all. So they were working for these large firms for large amounts of money. I went a different direction. I talked to some people I know, and I asked them who the best trial lawyer they knew was, and they said Steve Smith. So I came to work for a very small firm for a much smaller amount of money in Orange County, where, as some of you who may be there know, is kind of the trench warfare of small business litigation. I got to depose somebody on my first week, whereas I have friends who, even though they've graduated from law school for several years now, haven't had that chance. It's been an amazing education. And one of the things that we've learned at our firm is that an attorney who spends 10 years writing contracts, writing waivers, and drafting these things doesn't know as much as an attorney who spends 1 year fighting about waivers in court and trying to attack a contract or trying to defend a contract against somebody else who's trying to attack it. It's in the fight that you learn where the strengths and the weaknesses of your documents are. And that's one of the things that we've learned in our practice and we've been able to put into effect as we've kind of transitioned a little bit from our only litigation strategy to a strategy of advising businesses as kind of an outside general counsel on the strength or weaknesses of their contracts, on the things that they need to look for in their contracts and how to make their contracts as strong as they can possibly be. So that's a little bit about what we're going to discuss today. We're going to go over why we have waivers and releases, the risk factor, what a waiver is, what it can do for you, what makes it enforceable, and we'll talk a little bit more about that enforceability term, and particular interest, waivers regarding children and teenagers, and then some other issues. So first of all is the risk factor. The reason we are dealing with waivers is because we deal with risk. And in particular, the risk we're talking about here is liability, litigation liability. Now, liability can arise in a number of different ways. You could have an instructor that's not paying attention, and a child can injure themselves with the dangerous object. A piece of equipment might malfunction. A child could be running across the pool surface and slip. If you're serving food, you could have a child get food poisoning or have an allergic reaction that you didn't anticipate. This list could go on for days. There is no end to the ways that a litigation liability can develop. The risks are inevitable. This is what one court said. A risk is inherent in many of the activities that make the lives of children richer. A world without risk would be an impoverished world indeed. There's no way to avoid it. How do you eliminate risk? There's only one way to do it. You close your doors. How many of you are from California or know of what Prop 65 is? All right, so Prop 65 is a California-specific law. If you don't know about California's weird proposition system, in addition to having a legislature that does nothing or harmful things, like most states, we also have the opportunity as citizens to vote on propositions. These are put on the election ballot in November if they get enough signatures, and if enough people sign them, they become the law, part of the law of the state, or even part of the Constitution. We had a big issue with Prop 8 a few years ago, you may have heard about. Well, Prop 65 is one that came out several years ago, and it said, basically, if a product contains one of a few listed chemicals that are known to cause cancer or birth defects in a specific amount, and that amount's roughly a 1/1000th of the amount that we know can cause a harmful effect. If a product contains this and needs to have a warning on it. And if you travel around California, you'll see these on restaurants and maybe on packages and things like that. They're all over Disneyland. And it'll say, warning, Prop 65. This product or this location contains materials that are chemicals that are known to the state of California to cause cancer or birth defects. So, we have a client that's a nutritional supplement company, and they're shipping their products, nutritional supplements, into California, and they got a notice from a nonprofit saying, hey, we just tested your product and we found that it has lead over the amount that Prop 65 allows you to have. And we looked into the product as well, and we confirmed that it did have more than Prop 65 allows you to have, because it contained vegetables, and vegetables have more lead than Prop 65 allows you to have. Now, when the legislature looked at this law, at this proposition, and put the regulations into effect, they thought, well, we're probably not going to worry about vegetables, so green beans may have 50 times more lead than Prop 65 allows, but we're not going to require green beans to have a label. But if you put green beans in a product, then you have to have the warning on it. So my client made the decision to eliminate the risk altogether, and they stopped shipping the materials to California. That's the only way to eliminate the risk. That's not really an option for us, though. So what we're going to do is we're going to shift the risk. The risk is still going to be there. But what we try to do is take the risk off us and move it to somebody else. There's a few different ways we can do that. One is you can operate in specific jurisdictions that move the risk automatically. One, for example, the state of Virginia has laws on the books that some recreational facilities have limited liability by statute. They don't have to sign waivers. In fact, in Virginia, if you sign a waiver, a parent signs a waiver on behalf of a child, it's not enforceable at all. But the statute says, look, we're going to limit liability in certain cases. So you can operate in those jurisdictions. That can limit your liability or shift the risk to the participant. You can invest in safety. There's obviously, you can train your employees to have safe practices. You can also invest in equipment that is safer. That shifts the risk as well, or at least lowers the risk. You can purchase insurance. That, in return for what the premiums you pay, the risk gets shifted to your insurance company. Now, the safety, investing in safety and purchasing insurance, in order to get the risk gone altogether, it's probably going to be cost prohibitive. You can't train your employees so that there is no risk. You can't buy equipment that is entirely safe no matter what. If you want to get rid of all your risk altogether, your insurance premiums are probably going to be cost prohibitive. But they can shift some of the risk. So another tool that we use are waivers and releases. So Some key definitions. Waiver is the voluntary relinquishment or abandonment, express or implied abandonment, of a legal right or advantage. A release is the act of giving up a right or claim of the person against whom it could have been enforced. And another term that we sometimes use in the law is called an exculpatory clause. It's a contractual provision relieving a party from liability for a negligent or wrongful act. Now, you'll see these terms, different contracts will use different terms, different courts will use different terms. Sometimes courts will use these terms in the same case interchangeably. It doesn't really matter what we call it. The same thing applies. It's a document, a contract, in which one party agrees to take some of the risk on themselves in return for being able to participate in an activity. And that's what we're looking to do. So these are some of the rationales for risk on the business side. It can limit your liability. A liability meaning the damages that could accrue to you if you did not have the waiver. So in an ideal case, if somebody got injured at your facility due to your negligence or the negligence of one of your employees, absent any other agreement or any statute or any other law, that would be your risk. If that happened, you could be found liable and you would be responsible to pay for that person's medical care, or even in some cases for their pain and suffering or other damages. So a waiver can help in some cases that we'll talk about to limit that liability. That can be a very big deal. We'll talk about a couple cases later on to explain exactly how much of a deal that can be. Waivers can also reduce the cost of your insurance. Some insurance companies, if you've got good waivers in place or you have good practices regarding waivers, they'll agree to lower your premiums in return for your agreeing to abide by those practices. Another rationale for having waivers, and this is something else that we'll talk about at the end, is that it helps educate participants as to what they're going to be doing and the risks that they'll be taking on. A waiver, and ideally, a waiver is going to describe the risks that are inherent in a company's actions. So if it's a swimming facility, there is a risk of drowning. There's not going to be a risk inherent maybe in a gymnastics company, but it is a risk inherent in swimming. So that's a way to describe the risks that are possible so that a person comes into this situation with their eyes wide open and makes an informed decision about whether they want to participate in this activity. So if somebody has a condition, for example, that they've got fragile bones, I have 4 children. My 5-year-old, when she was, a couple years ago when she was 3, had decided apparently to stop eating any vegetables or drinking any milk whatsoever, to the point where she had what we joked were hollow bones. She fell off her bed, it's about 18 inches off the ground, and broke her collarbone. It was just astonishing. So since then, she has bulked up considerably, and we roll her off the bed all the time now, and it's no problem. But if somebody has a condition like that, it's good for them to know in advance that a broken bone is a possibility. And a waiver can be a good way of informing them that this might not be the right activity because it describes those things. Waivers can also have a good, another good thing about waivers is they can make your interactions with customers more predictable. A waiver can have an arbitration clause or a mediation clause that says, look, we're not going to go into the wild, wild west or the trench warfare that is the California court system or the court system of any other state or country. We're instead going to do a little more civilized arbitration, a little more informal, a lot faster, and something that gives you a little more satisfaction and security that you're not going to just be totally, excuse language, screwed over by a random jury or a random judge. When we have people come into our law firm and say, you know, here's the facts of my case, what do you think my chances are of winning? We'll go through and we'll analyze it, and based on our experience, we'll give them a number, and it'll be somewhere between 10% and 90%. You can't do any better than that. There are judges who are crazy, and juries are really crazy. Juries will do things that no rational person will do. They will make decisions that defy logic and reason, and we can't do anything about it. We can be the best lawyers in the world, and we can have all the facts on our side, and in a rational world, we would win 100 times out of 100, but the best we can do in the court system is 90 out of 100, because there are factors beyond our control. So things like arbitration and mediation can make it a little more predictable to get into a little better situation, that you're not in that wild, wild west, a little bit out of control situation, and they can be a lot faster. We talked about this one case that Steve's involved with today that's been going on for 4 years. That is not uncommon. We've had cases that have gone on for 10 years. There are cases that have gone on for 15, 20. So it can make it a little more predictable on how your interactions with customers, if things go sour, go, which can be helpful. So those are some business reasons. There's some legal reasons too. Waivers promote good public policy. On that second point, we live in a free society here, and we want to have the ability to sign contracts that shift risk. We want to be able to say, look, I really want to skydive, and I'm willing to take the risk that something would happen if I go skydiving that could result in my injury or possibly in my death. I'm willing to take that risk. If we didn't have waivers, we wouldn't have the ability to do that. Then those businesses couldn't exist because they couldn't handle the liability. So that's good public policy. And there are some activities that just you couldn't have happen without waivers. Waivers can also decrease litigation costs. They can induce one party to say, look, I'm not going to sue at all. And it can also be a really powerful tool to get a case dismissed or resolved before trial. We'll talk a little bit more about what that means in a minute. So, those are all good reasons for waivers. What can't waivers do? No waiver is going to be an ironclad protection. You can have the best waiver in the world. It's not going to save you every time. We've talked about the 90-10. But there's other things as well. There's still going to be litigation costs. If somebody gets injured at your facility and you have a fantastic waiver, you can still get sued. A person can sue you no matter what. Even if they're crazy and their attorney is crazy, they can still sue you. That's the right that they have. And that's going to cause you to incur costs. So a case proceeds roughly along the lines of somebody files a complaint, and then if you're a defendant, you have to file an answer. And an answer which requires also some investigation of the claim and the facts and everything else. That can cost, in attorney fees, $5,000, $2,000, $10,000. That's not insignificant, and that's just the first step. After an answer, we have what's called the discovery process, where the other side asks questions. What were the situations? Who are the employees? What type of training do you do? And you have to provide all these answers, and you get to answer questions back. You know, was there any condition in this person's health before this? Did they already have this as a pre-existing condition? Did they take adequate steps to protect or train? That process goes on, and that process can cost tens of thousands of dollars. After discovery, you've got motions. We have what's called the motion for summary judgment, which basically says there is no way that this person could win at trial. The facts are such that we're going to win at trial every time. Therefore, it makes sense to get rid of this now at the summary judgment process. A motion for summary judgment can also cost $10,000 to $15,000 to get prepared and filed. We've got to file a motion. The other guys get to oppose it. We file a reply, and then we all go into court, and we have an oral argument with the judge where we present orally things that we've talked about they present orally, and the judge makes the decision. So that can be a long process. I have a friend who's an attorney. He filed a motion for summary judgment 3 years ago. The court ruled on it this year. So that whole time, they had to continue to pay the attorneys. The case kept going while the court was apparently deciding for 3 years whether it wanted to grant summary judgment. It did. And that can cut off the costs early, but at the same time, you still have those costs all the way up to summary judgment, and they can be not insignificant. Now, they're a lot less than trial. Right now, in Steve's trial, Steve is there. He bills at about $400 an hour. There's another partner on the case. He's billing at about $350 an hour. An associate's working on the case at $250 an hour, and we've got an outside counsel also on the case around $300 an hour. That is roughly $1,200 to $1,000 for every hour that they are working. They are working, when they are in trial, 10 to 12 hours a day on that case. So the costs at trial will increase exponentially. So a waiver, if it can get rid of you having to go to trial, can save $100,000, $1 million of trial costs, but you're still going to have the costs leading up to that. So it's not the be-all, end-all there. Product liability and gross negligence cannot be waived. Gross negligence is negligence that is so extreme that courts say, look, it's not the same thing. It's beyond all human decency. You can't waive it. You also can't waive product liability claims. If a product is defective, the manufacturer made it in a way that's defective, you can't waive it. Now, if somebody sues you for a product that you've purchased and are using in your facility, and that product is defective, you will be able to turn around and sue the manufacturer, but it won't get you out of, your waiver won't be able to get you out of the case either. You'll still be on the hook, even though you can seek some indemnity from the manufacturer in that case. A waiver can't protect you against intentional torts. An intentional tort is any act that requires, this is the legal term, the element of intent. So these are things like assault or intentional infliction of emotional distress or an invasion of privacy. Somebody, an employee, intends to harm another person, one of your customers. That can't be waived. Those are going to, a waiver that says we also waive our any intentional torts, a court's going to toss it out. It's not going to even give it anything, any sort of enforceability. So there's those issues, and also the waiver itself may not be enforceable. It may have been drafted incorrectly. It may not cover the things that you want it to cover. That is something we can can do something about. These first four we may not be able to address, but the last one we can. So, talk about some waivers and whether they're enforceable. This waiver was, and you can see it's very legally written. It makes sense. I assume all these risks. I'm aware of the risks. Court said it's enforceable. Good waiver, case dismissed, defendant doesn't know any money. This is the second waiver, also written in a very legally, a very legal way. It's got all sorts of legal terms in it. Frankly, it's really similar to the other one, and a court said it's not enforceable. It's unenforceable. It said it doesn't matter that this person signed the waiver for reason X or Y. We're not even going to talk about it. It's not enforceable. This case can proceed as if no waiver had been signed. The risk wasn't shifted. So, no waiver is going to be immune to attack. It could be, and here's some reasons, too long, or it could be too short. It could be too simple, or it could be too complex. A court will look for a reason to get rid of a waiver, and they'll look for it because the attorney on the other side is going to say, Your Honor, It was simply too long. We had no idea what we were signing. It was 15 pages long. Or, Your Honor, it was too short. It just didn't cover enough. The other side's going to come up, is going to attack it. So that's another reason lawyers or waivers get not immune. There are too many lawyers, and specifically too many of the wrong lawyers. We try to be the right lawyers at our firm, but we have dealt with good lawyers and we have dealt with bad lawyers, and there are really, really, really bad lawyers out there. Lawyers who will pursue claims that have absolutely no merit. It's almost like an extortion scheme. You know, at some point, you're going to pay something just to get rid of this annoying lawyer or this annoying lawsuit. There are bad lawyers out there. The other issue is not enough of the right lawyers. Your waiver wasn't drafted properly. It wasn't put together the right way. This is something that, in my experience, in litigating a lot of cases, in dealing with a lot of contracts, and also in drafting and reviewing contracts, I can't tell my clients enough. The old aphorism, an ounce of prevention is worth a pound of cure. This is where it happens. I charge $300 an hour for my services. I don't get paid that, but that's what my law firm charges for the work I do. That means if you send me an email and I read the email regarding a matter that I'm representing you, I get $30, or my law firm does. Doesn't matter if it's a 2-sentence email. That's expensive. And it could take me to review a contract an hour or two. To draft something from scratch and to do some investigations, it could take me all day. You're talking $300 to, $600, $3,000 maybe. But paying me $3,000 or paying another attorney $3,000 is so much better if it saves you $300,000 because you just got rid of one lawsuit that you would have otherwise had. It pays for itself. So, what are the factors that make a waiver more enforceable? These are a few of the things that courts have said, these are the important things on a waiver. So, first, use clear and unambiguous language. You want your waiver not to be the most legally slick thing that you've ever seen. You want your waiver to be something that a parent off the street or a person off the street can say, yes, I understand what that means. It's saying I could get injured in this way, or maybe an unknown way. And I'm agreeing that if I'm allowed to participate here, that risk is on me. Even if they slip up a little bit, I'm going to bear that risk, and I'm willing to do that. A waiver should be something that's so clear and unambiguous that a person says, I understand that, and I'm going to go forward anyway. Courts have held that you don't have to have certain legal terms in there, like negligence or bodily injury. A court's going to look at the intent. And if the intent is, I'm trying to slip one past this person, I'm trying to get them agree to more than they know they're agreeing to, then a court could say, no, not enforceable, wasn't clear and unambiguous, we're going to treat it as if there's no waiver. So, number one, clear and unambiguous. Along those same lines, you want the text to be readable. This is not a fine print situation. It should be 10-point font or more. And this is not something where you're trying to slip something by someone. That same issue, you want it conspicuous. If it's in a contract, if you have a waiver provision in a contract that deals with other things as well, then you want the waiver to be set off and conspicuous. Ideally, you just want a separate document. A waiver doesn't have to be long. It can fit on a single page. And if you have a single page waiver, and that's all it deals with is the waiver issues, that is the best. That is ideal. Because a person can't say, well, yeah, I saw the title and it was about this, and I glanced through some of it and it was about this. I'm sorry. They can't say that. They'll say, look, it says waiver on the top. It talks about waiver. It doesn't talk about anything else. That's the best. One thing you definitely do not want is you do not want your waiver language on your registration form. That's a big no-no. You want to allow time for the person to review it. You want to give them the opportunity to say, look, I had time to do it. We weren't rushed. And the reason is, a court will not enforce a waiver unless it was, and these are legal terms again, knowing and voluntary. A person who enters into a waiver knowingly and voluntarily can be held to it. A person who did not know or who did not voluntarily sign is not going to be. We had a case regarding a person who got injured on a high school trip, his high school senior trip. A travel agency that we represented set up the trip. They were going down to Mexico. And as part of the documents before the trip, they presented this whole trip. They said, this is where we're going. We're going to this city and this city and this city. Stay at this hotel and this hotel and this hotel. They presented a document, and part of the documents were a waiver. And the parents had to sign the waiver saying this. And this parent, in the case that we represented the travel agency, took the waiver home. She glanced through it. She signed it. Kids went on the trip. This parent actually went with them. They were at a hotel in Mexico. They were standing outside by the pool, and one kid decided it would be funny to grab the other kid and jump into the pool with him. The pool was more shallow than your typical pools, and something happened, and the kid that got pushed in hit his neck and became a quadriplegic. They got him out of the pool. His mother was there. She was a registered nurse, and she gave him medical help, but this was an irreversible thing. So as part of this, this kid and his parents sued the boy who pushed him in, the hotel in Mexico, and the travel agency, in addition to a couple other people. They couldn't find the owners for the hotel in Mexico to serve them, and they settled with the boy, who obviously didn't have as much money as the travel agency. So they were just coming after our client. And we went to take the deposition of the mother who had signed the waiver. And we talked with her in the deposition. We said, look, did you see this waiver? Yes, I saw it. And did you look at it? Yeah, I looked through it. I scanned it. And this paragraph says that you agree you're going to waive your claims if something happens, you get injured. And you saw that. Yeah, I saw that. And this one says that you could get injured in X, Y, and Z way. And you saw that. Yeah, I saw that. And you signed at the bottom agreeing to this. Yeah, well, I had to, otherwise he couldn't go on the trip. But what did it mean to you? Well, it meant that if he got injured, that was going to be on us. And immediately after that deposition, we filed a motion for summary judgment saying to the court, Your Honor, she signed the waiver, she knew what it meant, she entered into it voluntarily, and the court said, that's right. And they agreed, and they dismissed our client. That's an ideal situation, but you have to be knowing, it has to be knowing and voluntary. So if there's a long line and the person's at the front of the line and they have to sign the waiver and they're feeling pressure and they don't have time to review it, that could be something that a clever lawyer could say, wait, it wasn't voluntary. You were making them all sign it in the same line and they didn't have time to review it, so you want to make sure they've got time to review. You want to make sure you don't try and overextend your waiver. We talked about gross negligence. If you try and waive gross negligence, a court's going to toss it out. Intentional behavior, a court's going to toss it out. And product liability. We had another case in which we represented the plaintiff. This was a man, a veteran who was a weightlifter, and he went into a gym, a famous global gym, and signed their standard waiver that had been drafted, by lawyers who get paid far more than me and who are probably far better at that sort of thing than me. And he signed their standard waiver and he went and he worked out. He worked out on a specific machine and he'd done it a number of times before. But there was an issue with the machine that, and I'm not exactly sure as I remember now what it was, but effectively it became, if you did something that was not totally abnormal, it became like a guillotine. And something came down on his neck, and it made him a quadriplegic. This time we were representing the plaintiff. And the other side, the gym, said, look, he signed the waiver. He waived anything. And we said, oh, no, no, no. This is a product liability issue. This piece of equipment was malfunctioned. It wasn't, it was designed in a manner that this could happen. And also, it's a gross negligence issue because there was a $20 part that if you put it on this machine, it would have solved this problem, and you knew about it. And even though you knew about it, you didn't do anything about it. That's gross negligence. That goes beyond everything else. And the court agreed with us. In the end, this plaintiff was awarded north of 8 figures on his claims, and it was because the waivers can't cover things like gross negligence and product liability. So don't try to cover them because the court can toss it out. And we'll talk a little bit later, you don't want the court to toss it out if you can avoid it. You do want them to waive negligence, though. Negligence is kind of the key to why we use waivers. If there's something that goes on that is just a minor slip-up, your employee should have done something, but they didn't, that's what you want in your waiver. So include that term or something to that effect. You don't want group signatures. You don't want, here's the waiver and here's the signature for the 13 participants or their parents or anything else. That's less effective. It needs to be individual for the participant. If possible, make it available before it so we're not rushing. That goes back to that knowing and voluntary. It needs to have consideration. This is another legal term. Your first year in law school, they talk about the elements of a contract. And one of the 4 elements is consideration. It just means I give you something, in return you give me back something. A contract where I only give you something is not enforceable. If I write down on a piece of paper, I am going to give you $100 and give it to you, and you sue me and say, Your Honor, he gave me this paper. It says I'm going to give you $100. The court's going to say no. Doesn't matter. But if I say, if you give me that piece of paper, I'm going to give you $100. If you go to the court and say, hey, I gave him the piece of paper, a court will say, okay, there was consideration. The court doesn't really care that it was worth what the other thing is. There's not sort of a balancing test of, well, a piece of paper is not worth $100. The court just cares that there is consideration. So in the case of a recreational facility, being able to participate is something that the facility gives in consideration of the person agreeing to waive negligence and other issues. But you want to make sure that the contract or the waiver states that there is this consideration. In return for being able to participate, I agree that so-and-so. You want to list the potential injuries. This is something that we talked about before about informing the other person. It's also something that a court looks at. Ideally, if somebody gets injured and they've signed a waiver, if the injury is specified in the waiver as, you know, there's a broken bone as a possibility and they break a bone, a court's going to say, look, you agreed that if you broke a bone, that's going to be covered. So you want to list those injuries that are more likely. You're obviously not going to be able to list everything like we talked about, but you want to list those more likely. The words permanent injury or death, you probably want to include that unless you're 100% sure it's not a possibility. You want to include unknown risks as well. The specifics will help if the specific injury happens, but if something happens that you weren't expecting, you don't want to be limited to only those few things that you did list. You want to renew your waivers too. You can have a waiver, you can have a person coming to your facility for 10 years in different programs as they advance through the classes. You want to get a new waiver for each class. An old waiver for the old class may not be applicable to the new one. And contracts have to have a term. They can't be from now until the end of time. So if a contract doesn't have a term in it, a court could toss it out. And then there are some other issues that can be, they can pertain to specific jurisdictions, they can pertain to certain activities or certain facilities, they can be pertain to different classes. A couple of issues that we looked at in cases is there was a waiver that the waiver said, I waived things regarding the activity, but it didn't say a waiver regarding the equipment, and because the equipment was involved, the court said the waiver doesn't handle it, the waiver doesn't cover it. Another one, actually that second one we looked at in the examples, it was release. The title of the document said release, but nowhere in the document, in the body of the document, did it say release. These are kind of the nitpicky technical things that a lawyer can catch, that a lawyer can look at, and can say, look, I want this and not this. But you want to be able to say that you want to be confident that your waiver is not going to get tossed out on a technicality. Now, if there is something in the waiver that is would render it unenforceable, you want to have what's called a severability clause. This just is something that says, look, if there's something in there that we think that a court finds is not enforceable, if there's something in there the court says, no, 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 I don't agree with that, okay, toss that part, but keep the rest of it. An attorney attacking a waiver can attack it for all sorts of reasons. And they may not be attacking the part that you're really going to depend on. But you don't want the baby to get tossed out with the bathwater. So you want to have something in there that says, you know, to the fullest extent permitted by law, or something else that can save the real critical part of the waiver, even if some other parts that aren't as important get tossed out. There's also some other general contract terms that an attorney can help you with as well, like jurisdiction. You want to use California law where parents can waive things on behalf of their children instead of Virginia law where they can't, or something like that. With all that being said, there's no such thing as a perfect waiver. Every situation is unique, every circumstance is unique, and the waivers and the law varies from state to state. So, just talking about children, children can't sign waivers. If a minor signs a waiver, that waiver can be fully legal and binding until the minor says, I don't want it to be legal and binding anymore, in which case it's not. Courts have said that minors, anybody under the age, and this may vary state to state, usually 18, a minor can void a contract at their will. They can say, I no longer want to abide by this contract, even though I signed it, even though I got the consideration, I'm done. So having the child sign the waiver or the teenager sign the waiver, it won't do anything to help you. The law will protect them and at your risk. So, in many cases, we seek to have the parents sign. This is going to vary, though, from state to state as to whether it's enforceable. In California, for example, parents can sign waivers for their children. That case I talked about, the travel agency, that was a parent signing on behalf of, I believe it was a minor child. But in California, the court says yes. If a parent signs it and they waive it, that waives the child's rights as well. And there's two different things to think about here. And I'm going to try and finish up. I think I'm running long. If a child gets injured, child obviously has a cause of action or a claim regarding their injury. But their parent can also have a claim as well for emotional distress into seeing what happened to the child, or for something else. So a waiver is, in every state in the United States, a waiver can be effective to waive the parent's claims. But in some, it won't be effective to waive the child's claims. Texas, by statute, says yes, they are okay. Tennessee says no, they aren't. Tennessee case, this is this Childress versus Madison County case. Really quickly, the court said, look, the parents signed the waiver, they agreed that all the claims were waived, and the court said the waiver was enforceable against the mother who signed it, but it wasn't enforceable against the father who didn't sign it, and it wasn't enforceable against the child who didn't sign it. In this case, a 20-year-old mentally disabled person. And so their claims, the father and the child, could continue regardless of the waiver. It stopped the mother's claims, but not the child's or the father's claims. So it's important that you know in your jurisdiction whether a waiver is going to be enforceable or not. Now, we did a quick survey based on some resources we could find. I'm not going to vouch for any of this because these things change, but some states allow waivers for nonprofits. If you don't accept a fee or a commission for the services, then a waiver can be effective. But if you do accept a fee, then it won't be. Some states are the other way around. If you do accept a fee, then the waiver can be effective, but if you don't, then it won't be. Some states like California allow it for both. A parent can waive a child's claims no matter whether it's a for-profit or nonprofit situation. A lot of states have said no. Some of these, like we've talked about Virginia, they've got other policies in place that say we're going to limit liabilities in other ways, but courts have said you can't waive it. And then there's a bunch of states where we actually don't know. It hasn't come up. The court hasn't been addressed by the highest court in the land. And then some of these are changing. This is a recent list that we got, but even New York has gone into the not allowed or allowed only for nonprofits. There's a law in the books now that says if you get a fee or commission, then a waiver is not going to be effective. But these are changing all the time. The trend is to allow more waivers than not. So as the trend continues to allow more waivers, some of these states are going to move up into these other columns. It's important that you consult with your attorney to figure out whether your state is going to fall into that. Talk a little bit about electronic signatures. More and more states are allowing electronic signatures. There are specific requirements, though, in almost every state about whether an electronic signature is valid or not. I have a case right now about electronic signatures where it's not valid because some of the things weren't on the website. Some of the terms weren't on there. And they had inhibited the ability to print the website. And in California, if you inhibit the ability to print out a contract that you sign electronically, then it becomes not enforceable. So there are things you want to address with an attorney there. You're going to deal with people who don't want to sign your waivers. You want to explain that a waiver is a way that they get informed about what the risks are in these activities and how this and what could possibly happen and what this activity is like. And this is another reason, going back to that clear and unambiguous, that you want it somebody that they can understand. You want somebody to say, okay, I understand that it's a possibility that in a cheer program a child could break an arm. I understand that. I'm willing to go forward anyway. And if they're not willing to sign the waiver, you got to be willing to let them go. That's a warning sign. That's a red flag. You want to store your signed waivers. A waiver is no good if it doesn't exist anywhere except in your mind. I had a very long case about a contract, and one side said, well, the contract no longer exists, so nobody could find it. That case went on for years and years. And you want to be able to store them until the time that it's no longer going to be an issue. For a minor, the statute of limitations is going to run at the point where they reach the age of majority. In California, it's 18. So the 2-year statute only begins to run at 18. So for a 5-year-old, you're going to want to store that waiver a long time. Finally, and this is important, even if a waiver is deemed unenforceable, it can have two important effects. First, you can use what's called the acknowledgement or assumption of risk defense to say, look, the waiver may not be enforceable, the contract's not enforceable, but they knew what they were getting into. The waiver said X, Y, and Z were possible, and X is what happened to them. They assumed that risk going in. And even if the waiver is unenforceable, the court could say, okay, well, I agree, they assumed the risk, they knew what they were doing, and it could become an entire defense to the action, or it could limit damages. One commentator we looked at said a survey they did showed that it limited damages by like 35% because the person knew the risk they were getting into. And the other thing is that not everybody is going to sue if they get injured. Some people are never going to sue. My mother is one of them. She's never going to. She just doesn't like it. She doesn't believe in the system. That affects our relationship, obviously. But she's not going to. Other people are going to sue every time, no matter what. But there are people in the middle, people that may or may not, and they can be influenced. And even if a waiver is unenforceable, they may not know that. Or they may say, look, without consulting an attorney, it may be unenforceable. I'm not going to get into it. I'm not going to worry about it. So even if a waiver is unenforceable, it may influence that person not to sue. And that can be just as effective in limiting your liability and costs. Thanks for having me today. I appreciate it.